Military reserve members and their civilian employers are watching a Supreme Court case closely. It involves a Coast Guard reserve member who claims the FAA owes him 2 years' worth of military pay differential. A lower court ruled otherwise, so he appealed. Details of the case now from attorney Sean Timmons, a managing partner at Tully Rinckey. Sean, good to have you back.
Thank you for having me here this morning. I really appreciate the opportunity.
Give us the outlines of this case.
Well, it's been going on for quite a few years, but on June 24, 2024, Supreme Court granted certiorari this case.
It's Air Traffic Controller Nick Feliciano versus the Department of Transportation.
It involves the Merit System Protection Board's denial of differential pay to Nick Feliciano, an air traffic controller with the FAA, and as a member of the Coast Guard Reserves.
And it's a Uniformed Services Employment and Reemployment Rights Act case.
The USERRA experts are divided on this case and how the Supreme Court's ultimately going to come down, but it could expand the access differential pay. The Department of Transportation is trying to take a very narrow interpretation to say that, your mobilization wasn't specifically tied to a national emergency and it wasn't specifically performing wartime duties, and differential pay is only owed during those particular predicate requirements.
All right, so the way it works is then if you are on reserve and you get called up and it's for a national emergency, then under law the government has to pay you the difference between your regular pay for the government or any employer and your pay while on duty for the military.
Yes, and that compensation differential can be significant because if you just join the military as an E1, your pay is, say, $2,000 a month, but you're a police officer for the Capitol Police making, say, $5,000 a month. I'm just doing a rough outline here. You could be a $3,000 or $4,000 a month compensation differential. So the employer here, the Department of Transportation, is trying to save allocated budget resources. So we're going to narrow the interpretation to say individuals who are only called in very limited circumstances would be entitled to this compensation differential. So if you volunteer for mobilization, basically, you volunteer for a massive pay cut. That's what they're trying to say to the Supreme Court. The Supreme Court is skeptical of that interpretation and believes that differential pay access should be expanded. So
how do we know that's how the court thinks?
Well, you can hear it from the arguments and questioning. You heard from Justice Sotomayor, Justice Kagan, Justice Alito, all very skeptical of the position that this should be narrowed.
Right. So someone then, under the way the lower court interpreted this and the way the FAA interpreted it, is that if you are called, but it's not for a national emergency, Coast Guard needs you, although why they would call up the reserves for ordinary purposes, I guess we don't know. But if it's not an emergency, then you just lose the differential. You just get paid by the military for that period. That's
correct. You would just get your normal military compensation, which in some cases could be equal to your civilian employment or your federal employment, but often it's less. The military is paid quite a bit less. Now, the military will respond and say, well, we have collateral benefits such as retirement, housing, food, other compensation that's not quantified. So there is a misnomer there. I mean, sometimes you are paid more in the military if you're getting free accommodations. However, often the compensation can be quite significantly lower, especially if you're a banking executive and you're making, or a pilot for an airline, and you're making $200,000 a year for an airline and you're making $100,000 a year as a pilot for the Air Force. You're talking about massive differentials in compensation. But
sure.
In some cases, the pay is not that far off.
We're speaking with attorney Sean Timmons. He's a managing partner at Tully Rinckey in their Houston office. And this gentleman, Nick Feliciano, then what do we know about the circumstances of his assignment by the Coast Guard for that period of time, 2 years? And he's saying that it was a national emergency.
Well, Nick Feliciano's case is unique because he was called during Operation Iraqi Freedom and Operation Enduring Freedom. So both of those mobilizations I would constitute were based on national emergency. Congress specifically authorized use of force in response to 9/11 for Operation Enduring Freedom, and they specifically authorized use of force under a continuing resolution to enforce the end of the Gulf War in 1991. So Operation Iraqi Freedom, Operation Enduring Freedom were both continuations of congressionally authorized wartime activities. Even though they weren't formal declarations of war, they were cases where Congress voted, debated, and authorized the use of force, and then the armed forces to mobilize, members of the team to fulfill the mission Congress specifically appropriated funds and authorized. So to say it's not an emergency or it's not related to the requirements on differential pay, in my opinion, is disingenuous.
Right. So Feliciano is arguing against a civil service board and then later the U.S. Court of Appeals for the Federal Circuit. Is the Coast Guard coming to his help in any way? Are they saying it certainly was an emergency? That's why we got the guy down here.
To my understanding, the Coast Guard has remained relatively neutral in their advocacy here. I think they have a statutory duty to try to stay out of it. And the Department of Justice, unfortunately, has to defend the government's invocation of the denial. So, but it's the FAA here that doesn't want to pay, and that's under the DOT. So it's kind of an interagency squabble here about who wants to do what.
Right. And do we know whether he's back to work during these intervening years as an air traffic controller?
That is my understanding, yes. So he's been reemployed. He's fighting for pay he wasn't receiving while he was mobilized.
The Supreme Court heard this case when, and when do you think they'll decide it?
They heard it back in October, and there was quite a few publications regarding the analysis, and the decision will probably come down in May or June, more likely June, towards the end of the year.
And do these kinds of cases pop up often, people suing for the differential pay that they were denied?
Not necessarily often. Many people don't know they're entitled to it. Many employers aren't really tracking that they should even compensate individuals for it. And individuals who do try to effectuate their rights often settle pre-lawsuit. So these cases are exceedingly rare. For to get to the Supreme Court is going to actually create a whole new chapter of case law, which will be interesting and studied for decades to come.
But if the Supreme Court rules in Feliciano's favor, then it would seem like that would be the case for everybody else now getting called, that could be presumed it was for a national emergency and that people could simply expect to get that differential pay.
The Supreme Court, Justice Kagan, Justice Thomas did allude to the fact of the scope of Pandora's box here, meaning everybody's going to want to get in line now for compensation they weren't paid and they weren't provided. But again, the statute says what it says. Congress to appropriate funds to enforce the statute, it's a whole other separate issue for the legislative branch to worry about. And yes, the Supreme Court does interpret the statute literally. I think they're going to open up claims for individuals who come back and say, hey, I was shafted. And the good news about that is USERRA has no statute of limitations. So individuals who were denied enforcement of the differential pay some 10, 20, 30 years ago, technically as the law exists now, won't be barred by any statute of limitations to effectuate their legal rights.
And you mentioned Kagan and Thomas, who were typically on opposite sides of just about every case. They agree that this is a Pandora's box. And then you earlier mentioned Alito and Sotomayor, also generally on opposite sides, as agreeing in favor. So it sounds like he'll win, but it won't be unanimous?
It could be a 7-2 or an 8-1 decision. I think the court's clearly going to side on the veteran. The statute in previous case law has usually required close analysis to be deferential to the veteran. That's in the legislative guidance all the way back to 1940. So I think the court is going, if I had to put money on it, I'd say the court's going to rule in his favor, but there may be a couple of dissenting votes regarding only because of the collateral nature of the expenditure associated with the relief granted.
We'll keep an eye on it in the meantime. Attorney Sean Timmons is a managing partner at Tully Rinckey. Thanks so much for joining me.
Thank you, Tom. I appreciate the opportunity to be with you this morning.
And we'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts.